Now, President of the Judicial Yuan, Honorable Chief Justice Xu Zongli, will give us an opening speech on how does the judicial activism of the Taiwan Constitutional Court shape the liberal democratic constitutional order in Taiwan. Let us give a big hand to welcome President Xu.
So, ladies and gentlemen, I'm greatly pleased to have the privilege of delivering this address at the moment of the 70th anniversary of the establishment of Taiwan's Constitutional Court. Over the past 70 years, Taiwanese society has experienced significant liberalization and democratic transition. During this process, the justices in the Judicial Yuan have also strived to perform the function of the Constitutional Court, aiming at establishing and defending the constitutional order in Taiwan. As such, my topic for today's presentation is how does the judicial activism of Taiwan's Constitutional Court shape the liberal democratic constitutional order in Taiwan? I seek to explore how the Constitutional Court examines the existing political decisions actively and thereby illuminates normative values as required by the Constitution. I will discuss numbers of leading cases and analyze them in 3 dimensions, which include Constitutional Court's contribution to democratization, political dispute resolution, and human rights protection. And before the formal discussion, I want to illustrate that the term judicial activism in my speech will mainly refer to its institutional dimension. This is to say, instead of showing deference to other political branches' decisions, the Constitutional Court would positively intervene in such disputes and scrutinize the political decisions more stringently. Before Taiwan's martial law was abolished, it was extremely limited for the Constitutional Court to exert judicial activism. During this period, even though judicial review had existed, it was not effective because of the overwhelming power of the executive branch. The Constitutional Court at that time rarely ruled a declaration of unconstitutionality, and a few of the progressive interpretations were also being neglected. However, in the late 1980s, the so-called Quiet Revolution has marked a dramatic shift, and Taiwan started on its path to political liberalization and democratic reform. Via the end of martial law era in 1987, a multi-stage constitutional reform was launched. In order to resolve dispute resulting from the reform, an arbitration mechanism is needed. Furthermore, the justice at that time must not merely take the political branch's opinion into considerations, but also need to satisfy the need for democracy from Taiwan society as a whole. Hence, the Constitutional Court, like a sleeping lion, which just awoke, gradually demonstrated judicial activism toward the political branches. So, I just mentioned, I will demonstrate the judicial activism in 3 dimensions. The first dimension is the contribution for political liberalization and democratization. I will give you 4 leading cases. The first one is interpretation number 261. It's related to complete re-election of the national legislatures. Interpretation number 261 was a shot in the arms for the process of democratic transformation. In the 1950s, the territory under governmental control was severely shrunk compared with the original claim provided by the Constitution. At the end of the first term of the national representatives, in order to maintain the nation's ruling territory assumed by the Constitution, the Constitutional Court ruled interpretation number 31, holding that all of the first-term representatives shall continue to exercise the powers until the re-election was de facto possible. Such action, however, led to a consequence that Taiwan failed to completely re-elect representatives for more than 40 years. Finally, in 1990, the National Assembly's self-expansion of extending their terms of office outraged the widely student movement in March. Dissolving the National Assemblies and the complete re-election became the earnest aspiration of all Taiwanese people. In the landmark decision of judicial interpretation number 261 in the same year, the Constitutional Court stated that the national representatives should terminate their power before the end of the next year, and the re-election should be held in a timely manner. Then the re-election of the National Assembly delegates and the legislature were both held in the following years. This time, the Constitutional Court successfully helped the society to take a crucial step toward democratic transition. So the second is interpretation number 445. Under the martial law regimes, various forms of assemblies and demonstrations were prohibited. After lifting the martial law, however, the Assembly and the Parade Act was not to loosen control immediately. In 1993, several environmental advocacy groups failed to apply for the permission timely yet still held the assembly as scheduled. Consequently, they were sentenced to criminal penalties. Several defendants therefore decided to challenge the constitutionality of the law. In interpretation number 445, the Constitutional Court explicitly recognized that freedom of assembly and parade was one of the most significant rights in practicing democracy. As such, the Constitutional Court adopted strict scrutiny and ruled the unconstitutionality of the provision which banned any speech related to advocate communism or secession of territory. Furthermore, the Constitutional Court declared several provisions neither specific nor clear enough through the clear and present danger standard. Through this interpretation, the Constitutional Court officially declares that such carte blanche laws to authorize public security department to prohibit certain political viewpoints should no longer be permitted. So the following one is the interpretation number 479 and 644. For authoritarian rulers in Taiwan, in order to maintain specific political ideology, citizen groups involved in specific political affiliation must be banned from the very beginning. The petitioner in interpretation number 479 was an academic association, and its attempt to change the name to Taiwan Law Society was refuted by the competent authority. In the decision, interpretation number 479, the court held that a free choice of organizational name fell within the protection of the freedom of association. In this case, the disputed provisions had already gone beyond the scope of the delegation granted by the enabling law. As such, the provision at issue had infringed the freedom of association and shall be declared null and void. And interpretation number 644 originated from a dispute in which the competent authority dismissed the application for the establishment of the new Taiwanese for Taiwan independence. The court considered that such restriction were the most severe restraint on freedom of association, and it was difficult to infer that the current state of the fact of the establishment would cause the imminent threat to the existence of the state or the constitutional order. Therefore, the rejection of the application was inconsistent with the constitutional guarantee of freedom of association. And now I will introduce another important interpretation, number 499. It's related to the boundary of constitutional amendment. At the Fifth Amendment of the Constitution, the National Assembly voted by anonymous balloting to extend its term of office. The action confronted strong public criticism. In response, the legislature submitted 3 constitutional petitions and argued that the amendment procedure and the amendment itself were unconstitutional. In 2000, the Constitutional Court announced interpretation number 499, holding that adopting anonymous balloting to amend the Constitution violated the principle of openness and transparency and rendered the electorate no way of checking the accountability of the delegates. Accordingly, the amending procedure was clearly and grossly flawed and should be held invalid. Furthermore, the court drew the line on the substantive boundaries of amending the Constitution. The court claimed that any amendment that changed the existing constitutional provisions concerning the foundation of the Constitution's very existence shall not be permitted. Such fundamental nature of Constitution, called the liberal democratic constitutional order, which encompassed the principle of the democratic republic, the sovereignty of and by the people, the protection of human rights, as well as the check and balance of governmental powers. The Constitutional Court considered that extending the term of the National Assembly would render the authority of National Assembly unable to be derived from the nation's entrustment, thus violating the governance by public opinion and the principle of the national sovereignty. In short, interpretation number 499 established the inviolable boundaries with respect to the constitutional amendment. Notably, the boundary is not associated to any specific national ideologies. Instead, it is narrowly limited within democracy, human rights protection, and the separation of powers, which are necessary to maintain the normal function of democracy, constitutionalism. Thus, preserving the flexible discretion for the political branches to reorganize the constitutional structure. So now I come to the second dimension, which is resolving the controversies across political branches. Due to the first party alternation in 2000, the DPP won the presidency of 2 terms of office for 8 years. However, the Pembroke coalition still controlled the legislative yuan, which led to a divided government. When the executive power and the legislative power were inconsistent and cannot adequately resolve political conflict, they tend to rely on the justice as an intermediary to reconcile this tension. In this period, there were at least 3 leading cases, but because of lack of time, I will only mention 1 case, namely interpretation number 613. The interpretation number 613 relates to Organic Act of the National Communication Commission. In 2005, the Legislative Yuan passed the Organic Act of the National Communication Committee. The NCC is in charge of the examination and the approval of the renewal of certificates for the broadcasting and the television industry. Subsequently, the constitutional petition was raised, and the executive contended that the appointment procedure of the members of the NCC had violated the principle of separation of powers. The Constitutional Court defined the NCC as an independent agency that exercises its functions independently from the hierarchical bureaucratic structure. Nevertheless, the Constitution still required the administrative unity and the political accountability of administrative power. So it was still necessary to retain the Premier's personnel authority for the NCC to a certain degree. So the Constitutional Court pointed out that the Premier was deprived of virtually all of his or her power to decide on personnel affairs, and therefore the disputed regulations were unconstitutional. So now I come to the 3rd dimension, is the protection of human rights. I'll concentrate on several aspects. The first aspect relates to ensuring personal freedoms. There were 3 related leading cases. I will only mention 1, namely interpretation number 567. It relates to forced labor. In the leading case, interpretation number 567, the disputed provision provided for convicted communist spy felons having completed a term of imprisonment but still lack of improvement in beliefs or behaviors, they may be sent to compulsory work. The so-called espionage refers to persons who commit civil disturbance and treason. In other words, the provision is dealing with the enemy of the state. In this interpretation, the Constitutional Court indicated that even in an extraordinary period, there was still a minimum level of human rights protection that cannot be derogated. Freedom of thought was the basis of human inner spiritual activity and freedom of speech. As such, no matter what kind of state of emergency was, the state would not be allowed to infringe upon it. Under this rationale, it was apparently a violation of the minimum human rights protection that the provision had provided that people's freedom could be deprived due to their flaws. And now I'll come to the problem of the protection of right to privacy. There are two leading cases, at least. The first is interpretation number 603. 603 is considered a representative case of how constitutional code implements the protection of privacy rights. In this case, constitutional code points out that preventing invasions of personal privacy and maintaining self-control of personal information was subject to the right to privacy prescribed by the Constitution. As such, since fingerprints were sensitive personal information, the large-scale collection of fingerprint data must be subject to strict scrutiny, and therefore the provision at issue were held unconstitutional. In interpretation number 689, Constitutional Court further addressed that even though in the public domain, there are still private areas of activity and information privacy rights that are not invaded by other people. As long as there is a subjectively reasonable expectation of privacy, and such expectation is aligned with social understanding, individuals can claim privacy protection in the public domain. Then the following, I will mention the protection of gender equality. Article 7 of the Constitution demands equality between men and women. The constitutional amendments required that the substantive equality of the status of the two sexes should be promoted. It apparently has shown that the Constitution does not make self-limitation of the so-called laws do not enter the family. Through interpretation number 365, 452, 457, and 636, Constitutional Court demonstrates courage to delve into injustice hidden in the field of marriage, family, or other traditional social lives. Examine whether the provisions which involve differentiated treatments between the sex strengthening the oppression against the female. And I will now mention the protection of same-sex marriage. The well-known achievement of Taiwan's Constitutional Court is Judicial Interpretation number 748, in which the justice recognized that the Constitution guarantees the same-sex marriage. Despite the timing of the declaration is not entirely uncontroversial. If we look back to 1986, the claimant has already filed a petition to the political branch and challenged the constitutionality of the relevant provisions. Furthermore, the strong opposition groups in the society have almost made the passage of the bill of same-sex marriage hopeless within the short term. In view of the constitutional dispute in this case, involves the essential fundamental rights of the people, and their rights have been suspended for more than 30 years. The justice, therefore, believe that the judicial judgment should be made in a timely manner. Besides, Constitutional Court also set up the 2-year term, urging the legislator to decide in which method they seek to implement the same-sex marriage rights. Only when the regulations were still vacated up to 2 years, the same-sex couple would be allowed to register to marriage directly in accordance with the provisions of the Civil Code. In any case, Constitutional Court chose to intervene in the highly controversial issue of same-sex marriage. Perhaps only interpretation number 499 can be slightly compared with interpretation number 748, paralleling as the peak of the judicial activism demonstrated by Taiwan's Constitutional Court. So finally, I'll come to end. Finally, is assessment and conclusion. To examine the idea of judicial activism, if it implies strict scrutiny of existing political decisions, the Constitutional Court will inevitably be in constant tension with the political branches which are responsible for leveraging and gathering pluralistic public opinion. As a result, the Constitutional Court must still reflect on its activist interpretations at the methodological level constantly. As a matter of fact, in the context of democratic transition, whether it's due to the defects of the existing constitutional structure or the conflict of political forces that are difficult to resolve, the Constitutional Court has always been no escape from intervening in the significant constitutional controversies. Therefore, the judiciary in a transitional society should bear the judicial function for promoting transformation in the specific political context. For countries which will dramatically shift to a democratic regime, their Constitutional Court is more necessary to resort to the normative constitutional value, assisting to disentrench the existing authoritarian system, or serve as a mediator between opposing political forces in the process of transition. In addition, although the Constitutional Court should appropriately respect the pluralism represented by the political branches, it's still necessary to comprehensively measure the types of fundamental rights involved in the dispute issues, the intensity and the urgency of the violations, the clarity of the demands in the constitutional norms, and even whether the group involved is in a vulnerable status in the society, to determine the standard of judicial review to be adopted. Hence, the Constitutional Court is never incapable of adopting judicial activism, but instead needs to individually determine that if there is a constitutional justification for adopting activism in respective cases. In this speech, I attempted to explore the contribution of Constitutional Court's judicial activism to the constitutional order in our country and provided several preliminary and rough observations. We are currently facing a global democratic backsliding, the rise of the authoritarian regimes which emerge in sharp power. All the conservative political forces that resort to xenophobia and racist dogmas continually challenging our commitment to the liberal values such as freedom, pluralism, and tolerance. However, in this wave of the backlash against the constitutional democracy. Taiwan has never stopped building up a constitutional community with democracy and human rights as its core beliefs, and sincerely believes that she can promote the prosperity and the peace of the international community with countries that share the identical beliefs. Walking through 70 years of constitutional development, Taiwan's Constitutional Court will proceed to accomplish its constitutional duties and constantly maintains a free, democratic, pluralistic, and inclusive Taiwan. Thank you so much for your kind attention.
We thank President Xi for his insightful speech. Please give President Xi a big hand. President Xi, please be seated.